Students, today we can analyze one more problem with regard to the Mohammedan law. As you know, in Mohammedan law, you will have the theory questions as well as the questions with regard to the problems. That means some illustration problem will be given and you are required to solve the illustration problem. So in the earlier video, I have told you the importance of solving the problem. That means here the importance of solving the problem is to test the logical reasoning of the student and knowledge of law, his observation of law, his understanding of the law, and the legal competence. So these are the requirements of the evaluator with regard to the how much the student knows the law. That means here the problem will be given in this direction, and this problem-based, problem-oriented questions will be given not only in our Karnataka State Law University. We can see in various law universities. Here, there are different methods will be adopted to solve the problems. So here, from the beginning in my videos, I was applying the method of FIRAC, that is the fact, issue, rule, analysis and conclusion. And there are also number of methods are there: issue, rule, analysis, conclusion, and other the methods will be there. But universally, this FIRAC method has been widely used among the law universities. ಅಂದರೆ ವಿದ್ಯಾರ್ಥಿಗಳೇ, ಈ ದಿನ ನಾವು ಒಂದು ಮಹಮ್ಮದೀಯರ ಕಾನೂನಿನಲ್ಲಿ ಒಂದು ಸಮಸ್ಯೆಯನ್ನ ಬಿಡಿಸೋಣ. ಅದರ ಸಂಬಂಧ ಯಾವ ಒಂದು 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 ಯಾವ ಒಂದು 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 ವಿಧಾನ, ಅಂದ್ರೆ ಆ ಸಮಸ್ಯೆಯನ್ನ ಬಿಡಿಸುವ ಯಾವ ಒಂದು ವಿಧಾನವನ್ನ ಅಳವಡಿಸಿಕೊಳ್ಳಬೇಕನ್ನುವ ಒಂದು ಸಂಬಂಧದಲ್ಲಿ ನಾವು ಈಗಾಗಲೇ ಒಂದು ವಿಡಿಯೋವನ್ನ ನಾವು ನೋಡಿದ್ದೀವಿ. ಅದರಲ್ಲಿ ನಾನು ಈ FIRAC ಮತ್ತೆ IRAC ಬಗ್ಗೆ ಹೇಳಿದ್ದೀನಿ. ಮತ್ತೆ ಇದರಲ್ಲಿ FIRAC ಅಂದ್ರೆ ಫ್ಯಾಕ್ಟ್, ಇಶ್ಯೂ, ರೂಲ್, ಅನಾಲಿಸಿಸ್, ಕನ್ಕ್ಲೂಷನ್. ಅಂದ್ರೆ ಇದನ್ನ ಏನಪ್ಪಾ ಅಂತ ಹೇಳಿದ್ರೆ, ಇದರ ಉದ್ದೇಶ ಅಂದ್ರೆ ಫ್ಯಾಕ್ಟ್ ಅಂದ್ರೆ ಸಂಗತಿ, ಇಶ್ಯೂ ಅಂದ್ರೆ ವಿವಾದಾಂಶ, ಪ್ರಾವಿಷನ್ ಆಫ್ ಲಾ ಅಂದ್ರೆ ನಿಯಮಗಳು, ಅನಾಲಿಸಿಸ್ ಅಂದ್ರೆ ವಿಶ್ಲೇಷಣೆ, ಡಿಸಿಷನ್ ಅಂಡ್ ರೀಸನ್ ಫಾರ್ ಡಿಸಿಷನ್ ತೀರ್ಮಾನ. ಅಂದ್ರೆ ಇದರ ಉದ್ದೇಶ ಏನಕ್ಕೆ ಸಮಸ್ಯೆಗಳನ್ನ ತಮಗೆ ಒಂದು ಪರೀಕ್ಷೆಯಲ್ಲಿ ಕೊಡ್ತಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ, ತಾವು ತಮ್ಮ ಒಂದು ಕಾನೂನಿನ ಜ್ಞಾನದ ಒಂದು ಅಳತೆಯನ್ನ ಮಾಡೋದಕ್ಕೋಸ್ಕರ ತಾವು ಎಷ್ಟು ಮಟ್ಟಿಗೆ ಈ ವಿಷಯದ ಬಗ್ಗೆ ತಿಳ್ಕೊಂಡಿದ್ದೀರಾ, ಮತ್ತೆ ಇಂತಹ ಒಂದು ಮಾನದಂಡವನ್ನ ಇಟ್ಟುಕೊಂಡು ತಮಗೆ ಸಮಸ್ಯೆಯನ್ನ ಕೊಡಲಾಗುತ್ತದೆ. ಮತ್ತೆ ಈ 80-20 ಈ 80-20 ಸ್ಕೀಮ್ ಅಲ್ಲಿ ತಮಗೆ 30 ಅಂಕಗಳಷ್ಟು ಸಮಸ್ಯೆಗಳ ಬಗ್ಗೆ ಪ್ರಶ್ನೆಗಳಿರುತ್ತದೆ. ಮತ್ತೆ ತಾವು ಏನಂದ್ರೆ ಈ ಸಮಸ್ಯೆಗಳನ್ನ ಸಕ್ಷಮ ರೀತಿಯಲ್ಲಿ ಬಿಡಿಸಿದ್ದೇ ಆದರೆ ತಮಗೆ ಹೆಚ್ಚಿನ ಅಂಕಗಳು ಸಿಗುತ್ತದೆ. ಸೊ ಆದ್ರಿಂದ ಈ ದಿನ ನಾವು ಡೋವರ್ ಅನ್ನುವ ಒಂದು ವಿಷಯದ ಬಗ್ಗೆ ನಾವು ಒಂದು ಸಮಸ್ಯೆಯನ್ನ ಬಿಡಿಸೋಣ. ಅದರಲ್ಲಿ ಈಗಾಗಲೇ ನಾವು ಈ ಫ್ಯಾಕ್ಟ್, ಇಶ್ಯೂ, ರೂಲು, ಅನಾಲಿಸಿಸ್, ಕನ್ಕ್ಲೂಷನ್ ಅನ್ನುವ ವಿಷಯಗಳ ಬಗ್ಗೆ ನಾನು ಈಗಾಗಲೇ ನನ್ನ ಹಳೆ ವಿಡಿಯೋದಲ್ಲಿ ತಮಗೆ ಅದರ ಬಗ್ಗೆ ತಿಳಿಪಡಿಸಿದ್ದೇನೆ. ಮತ್ತೆ ಈಗ ನೇರವಾಗಿ ನಾವು ಸಮಸ್ಯೆಗೆ ಹೋಗೋಣ. ಸಮಸ್ಯೆಯನ್ನ ಯಾವ ರೀತಿ ಈ ಫ್ಯಾಕ್ಟ್, ಇಶ್ಯೂ, ರೂಲ್, ಅನಾಲಿಸಿಸ್, ಕನ್ಕ್ಲೂಷನ್ ಅಂದ್ರೆ ಒಂದು ಸಂಗತಿ, ಮತ್ತೆ ವಿವಾದಾಂಶ, ಮತ್ತೆ ನಿಯಮ, ವಿಶ್ಲೇಷಣೆ, ತೀರ್ಮಾನ ಅನ್ನುವ ಹಂತಗಳಲ್ಲಿ ಯಾವ ರೀತಿ ಸಮಸ್ಯೆಗಳನ್ನ ಬಿಡಿಸಬೇಕು, ಮತ್ತೆ ಯಾವ ಮಾನದಂಡವನ್ನ ನಾವು ಇಟ್ಕೋಬೇಕು ಅನ್ನುವುದನ್ನ ನಾವು ಗಮನದಲ್ಲಿ ಇಟ್ಕೊಂಡು ಸಮಸ್ಯೆಗಳನ್ನ ಬಿಡಿಸೋಣ. ಇಲ್ಲಿ ಒಂದು ಸಮಸ್ಯೆಯನ್ನ ಕೊಡಲಾಗಿದೆ. ಇದರ ಪ್ರಕಾರ ಯಾವ ಒಂದು ಸಮಸ್ಯೆಯನ್ನ ಕೊಡಲಾಗಿದೆ ಅಂದ್ರೆ, ಒಂದು ಕನ್ಯಾ ಶುಲ್ಕದ ಬಗ್ಗೆ ಕೊಡಲಾಗಿದೆ. ಅಂದ್ರೆ ಈ ಕನ್ಯಾ ಶುಲ್ಕದ ಬಗ್ಗೆ ಮೆಹರ್ ಮತ್ತೆ ಡೋವರ್ ಅಂತ ಕರೀತಾರೆ. ಕನ್ಯಾ ಶುಲ್ಕದ ಇನ್ನೊಂದು ಅರ್ಥ ಏನಂದ್ರೆ ಅದನ್ನ ಮೆಹರ್ ಮತ್ತೆ ಡೋವರ್ ಅಂತ ಕರೆಯಲಾಗುತ್ತದೆ. ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ವಿವಾಹದ ವೇಳೆಯಲ್ಲಿ ರೂಪಾಯಿ 10 ಲಕ್ಷ ಕನ್ಯಾ ಶುಲ್ಕವನ್ನ ಪಾವತಿಸುವುದಾಗಿ ಸಲೀಮನು ಅಂಜುಮಳಿಗೆ ವಾಗ್ದಾನವಿತ್ತನು. ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ದ, ಒಬ್ಬ ಸಲೀಂ ಏನ್ ಮಾಡ್ದ, ತನ್ನ ವಿವಾಹದ ಸಮಯದಲ್ಲಿ 10 ಲಕ್ಷ ಕನ್ಯಾ ಶುಲ್ಕ ಮೇಯರ್ ಅಥವಾ ಡೋವರ್ ಅನ್ನ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಒಪ್ಕೊಂಡು ಒಂದು ಪ್ರಾಮಿಸ್ ಮಾಡ್ತಾನೆ. ನಂತರ ಆಕೆ ಪದೇ ಪದೇ ಅರಿಕೆ ಮಾಡಿಕೊಂಡರೂ ಸಹ ಅವನು ತನ್ನ ವಾಗ್ದಾನವನ್ನು ಉಳಿಸಿಕೊಳ್ಳಲು ನಿರ್ಲಕ್ಷಿಸಿದನು. ಅಂದ್ರೆ ಆತ ಕನ್ಯಾ ಶುಲ್ಕವನ್ನ ಪಾವತಿ ಮಾಡಲಿಲ್ಲ, ಏನೇ ಕೇಳ್ಕೊಂಡ್ರು ಆತ ಕೊಳ್ಳಿಲ್ಲ. ಬಾಧಿತಳಾದ ಅಂಜುಮ್ಳು ಪ್ರತ್ಯೇಕವಾಗಿ ಜೀವಿಸಲು ಆರಂಭಿಸಿದಳು. ಅಂಜುಮ್ಗೆ ಸಲಹೆ ನೀಡಿರಿ. ಈ ರೀತಿಯಾಗಿ ಪ್ರಶ್ನೆಗಳನ್ನ ಕೊಡ್ತಾರೆ ಒಂದು ಪರೀಕ್ಷೆಯಲ್ಲಿ. ಸೊ ಹಿಯರ್ ದ ಪ್ರಾಬ್ಲಮ್ ಹ್ಯಾಸ್ ಬಿನ್ ಗಿವನ್ ಇನ್ ದಿಸ್ ವೇ. ಸಲೀಂ ಪ್ರಾಮಿಸ್ಡ್ ಅಂಜುಮ್ ದಟ್ he would pay rupees 10 lakh as dower on the eve of the marriage. So one Mr. Salim, he has promised Anjum, that is the bridegroom has promised the bride that he is going to pay rupees 10 lakhs as a dower on the event of his marriage. And despite of her repeated request, he neglected to keep up his promise. That means he has not paid in spite of the several requests by the bride. So being aggrieved, she started living separately and advised the Anjum. So what she has done, she started living separately. So we have to solve this problem. We have to give our advice to the Anjum, what she can do. Then what is the law? What is the rule of the law? So we have to analyze these things. We have to analyze the fact, issue. We have to analyze the fact, issue, rule, and we have to give the conclusion. We have to see what are all the facts has been given. Even though the facts looks like very simple, but we have to give our in order to give our conclusion, we have to analyze all these things. We have to analyze the issue, we have to analyze the rule, and then we have to analyze these things. That means fact, issue, rule, we have to analyze it. ಅಂದ್ರೆ ಏನಪ್ಪಾ ಅಂದ್ರೆ ಸಂಗತಿ ಮತ್ತೆ ವಿವಾದಾಂಶ ಮತ್ತೆ ನಿಯಮಗಳನ್ನ ಅಥವಾ ಕಾನೂನಿನ ನಿಯಮಗಳನ್ನ ನಾವು ವಿಶ್ಲೇಷಣೆಗಳನ್ನ ಮಾಡುವ ಮೂಲಕ ನಂತರ ನಮ್ಮ ತೀರ್ಮಾನವನ್ನು ನಾವು ಕೊಡಬೇಕಾಗುತ್ತದೆ. That means the conclusion is at the last part. So we have to give the conclusion at the last part. But majority of the students, what they will do, they will write the conclusion at the first. So it is like seeing the movie at the from back to front. So this will be there, and they will not follow these steps. They are not concerned with regard these steps. So they will write the conclusion and they will write there on their own. So that sort of the answers will not fetch the marks. So here what we have to write, what we have to see, what is the rule of law? Is there any decided cases are there? So what is the issue? What is the issue between the plaintiff and the defendant? And what are all the facts? So these things we have to analyze it. ಅಂದ್ರೆ ಏನಪ್ಪಾ ಅಂತ ಹೇಳಿದ್ರೆ ಈ ಒಂದು ಸಮಸ್ಯೆಗಳನ್ನ ಬಿಡಿಸುವ ಸಂದರ್ಭದಲ್ಲಿ ನಾವು ಹೆಚ್ಚಾಗಿ ಆ ಸಮಸ್ಯೆಗಳಿಗೆ ಯಾವ ಒಂದು ಕಾನೂನು ಆಕರ್ಷಣೆ ಆಗುತ್ತದೆ, ಮತ್ತೆ ಅದರಲ್ಲಿ ಯಾವ ಒಂದು ಕ್ವಶನ್ ಆಫ್ ಲಾ ಅಥವಾ ಕ್ವಶನ್ ಆಫ್ ಫ್ಯಾಕ್ಟ್, ಅಂದ್ರೆ ಅದರಲ್ಲಿ ಕಾನೂನಿನ ಸಂಗತಿ ಏನಿದೆ, ಮತ್ತೆ ಒಂದು ಕಾನೂನಿನ ಸಂಗತಿ ಅನ್ನೋ ಕ್ವಶನ್ ಆಫ್ ಫ್ಯಾಕ್ಟ್ ಏನಿದೆ, ಮತ್ತೆ ಒಂದು ಕಾನೂನಿನ ಪ್ರಶ್ನೆ ಏನಿದೆ, ಮತ್ತೆ ವಾಸ್ತವದ ಪ್ರಶ್ನೆ ಏನಿದೆ. ಅಂದ್ರೆ ಇವಾಗ ಕಾನೂನಿನ ಪ್ರಶ್ನೆಯಲ್ಲಿ ನಮ್ಗೆ ಒಂದು ವೇಳೆ ಉತ್ತರ ಸಿಗದೆ ಇದ್ರೆ ನಾವು ವಾಸ್ತವಾಂಶಕ್ಕೆ ಹೋಗ್ಬೇಕು. ವಾಸ್ತವಾಂಶದಲ್ಲಿ ಏನು ಒಂದು ಪ್ರಶ್ನೆ ಇದೆ, ಅದರ ಆಧಾರದ ಮೇಲೆ ನಾವು ಸಮಸ್ಯೆನ ಬಿಡಿಸ್ಬೇಕು. ಅಂದ್ರೆ ಇದರಲ್ಲಿ ಹೆಚ್ಚಾಗಿ ನಾವು ತಲೆ ಕೆಡಿಸ್ಕೊಳ್ಳೋಂಗೆ ಏನಿಲ್ಲ. ನಾವೇನು ಒಂದು ವಾಸ್ತವಾಂಶವನ್ನು ನೋಡ್ಬೇಕು, ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತಹ ಒಂದು ವಿವಾದಾಂಶವನ್ನ ನೋಡ್ಬೇಕು. ಅಂದ್ರೆ ವಾದಿ ಮತ್ತೆ ಪ್ರತಿವಾದಿಗೆ ಯಾವ ಅಂಶಗಳ ಮಧ್ಯೆ ಒಂದು ಭಿನ್ನಾಭಿಪ್ರಾಯ ಇದೆ, ಅವರ ಮಧ್ಯೆ ಯಾವ ಒಂದು ಸಮಸ್ಯೆ ಇದೆ ಅನ್ನೋದನ್ನ ನೋಡ್ಬೇಕು. ಮತ್ತೆ ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ನಿಯಮಗಳು ಮತ್ತೆ ಯಾವ ಕಾನೂನು ಆಕರ್ಷಣೆ ಆಗುತ್ತದೆ, ಮತ್ತೆ ಯಾವ ರೀತಿ ಈ ವಿವಾದಾಂಶವನ್ನು ಬಗೆಹರಿಸಬೇಕು ಅದನ್ನು ನಾವು ಈ ಅನಾಲಿಸಿಸ್ ಅಂದರೆ ವಿಶ್ಲೇಷಣೆಯಲ್ಲಿ ನಾವು ಅದನ್ನು ಬರಿಬೇಕು. ನಂತರ ನಾವು ತೀರ್ಮಾನವನ್ನ ಬರಿಬೇಕಾಗುತ್ತದೆ. ಈ ರೀತಿಯ ಒಂದು ಮಜಲುಗಳನ್ನ ನಾವು ಸಮಸ್ಯೆಗಳನ್ನು ಬಿಡಿಸೋದ್ರಲ್ಲಿ ನಾವು ನೋಡಬೇಕಾಗುತ್ತದೆ. ದಟ್ ಮೀನ್ಸ್ ವಿ ಹ್ಯಾವ್ ಟು ಫಾಲೋ ದೀಸ್ ಮೆಥಡ್ಸ್ in solving the problems, not only this Mohammedan law with regard to the every law, every the subject, not every law, every subject. It may be special contract, it may be TecH, it may be constitution, or any the subject. So we have to solve the problem in these applying these the steps. So here what we have seen here, by reading this problem we came to know that there is a concept of Dower is there, and the bridegroom has not paid the Dower, so she started living separately. So how far she is justified? So what sort of the legal remedy she can get? So let us see from the facts, issue, rule and analysis and aspects, then we can give our conclusion. First, facts. So in the instant problem, one Mr. Salim contracted marriage with Anjum. Here what has been given here, they are not mentioned with regard to the contracting aspects. We have to simplify it. So as you know, the Muslim marriages are which are of the contractual in nature. That means here which are contractual in nature, and Dower is the consideration of the marriage of contract. So that aspect we know. So here what we have to simplify the facts. The next aspect is the amount of Dower at the time of marriage is fixed for rupees 10 lakh. Here there is a specification is there with regard to the amount of Dower that is a fixed for 10 lakhs, because there are so many kinds of Dowers are there. Probably here no, in your exams there may be separate question will be there. Discuss with regard to the Dower, or explain the concept of Dower, and discuss the different kinds of Dower. There is unspecified Dower will be there, and that will be there, and the proper Dower will be there. Here this will come under one section, and other aspect is specified Dower will be there, and specified Dower which can be divided into prompt Dower and the deferred Dower. ಅಂದ್ರೆ ಈ ಕನ್ಯಾಶುಲ್ಕದಲ್ಲಿ 4 ಬಗೆಯ ಒಂದು ಕನ್ಯಾಶುಲ್ಕವನ್ನು ನಾವು ನೋಡ್ತೀವಿ. ಅಂದ್ರೆ ನಿಮಗೆ ಪರೀಕ್ಷೆಯಲ್ಲಿ ಕನ್ಯಾಶುಲ್ಕವನ್ನ ಪರಿಭಾಷಿಸಿ ಮತ್ತೆ ಕನ್ಯಾಶುಲ್ಕದ ಪ್ರಕಾರಗಳನ್ನ ತಿಳಿಸಿ, ಆ ರೀತಿಯಾಗಿ ನಿಮಗೆ ಪ್ರಶ್ನೆ ಕೇಳಬಹುದು. ಅಂತ ಸಮಯದಲ್ಲಿ ಕನ್ಯಾಶುಲ್ಕವನ್ನ ಬಗ್ಗೆ ಬರಿಬೇಕು, ಮತ್ತೆ ಕನ್ಯಾಶುಲ್ಕದ ಪ್ರಕಾರಗಳ ಬಗ್ಗೆ ಬರಿಬೇಕು. ಅದರಲ್ಲಿ ಮೊದಲನೇದೇನು ಅಂದ್ರೆ ಅನ್ಸ್ಪೆಸಿಫೈಡ್ ಡೋವರ್, ಅದನ್ನ ಏನಂತ ಕರೀತಾರೆ, ಮಹರ್ ಈ ಮಿಸಿ ಅಂತ ಆ ರೀತಿ ಕರೀತಾರೆ. ಅದರಲ್ಲಿ 2 ರೀತಿಯ ಒಂದು ಡೋವರ್ ಇದೆ. ಅಂದ್ರೆ ಒಂದು ಯಾವುದು ಪ್ರಾಪರ್ ಡೋವರ್ ಮತ್ತೆ ಅನ್ಸ್ಪೆಸಿಫೈಡ್ ಡೋವರ್. ಅದರಲ್ಲಿ ಅನ್ಸ್ಪೆಸಿಫೈಡ್ ಡೋವರ್ ಅಂದ್ರೆ ಅನಿರ್ದಿಷ್ಟಪಡಿಸಲಾದ ಒಂದು ಕನ್ಯಾಶುಲ್ಕ ಮತ್ತೆ ನಿರ್ದಿಷ್ಟಪಡಿಸಲಾದ ಕನ್ಯಾಶುಲ್ಕ. ನಿರ್ದಿಷ್ಟಪಡಿಸಲಾದ ಕನ್ಯಾಶುಲ್ಕದಲ್ಲಿ ನಾವೇನ್ ನೋಡ್ತೀವಿ, ಒಂದು ತತ್ಕ್ಷಣಕ್ಕ ಒಂದು ಡೋವರ್ ಮತ್ತೆ ವಿಳಂಬಿತ ಡೋವರ್. ದಟ್ ಮೀನ್ಸ್ we can see there are 2 kinds of Dower is there. Under unspecified Dower we can see the proper Dower or customary Dower. Under specified Dower we can see prompt Dower and the deferred Dower. So here there is a specification of Dower is there. Here we can see there is a specification of Dower is there. As we can see here, there is a contract is there. There is what you call the contract is there with regard to the payment of the rupees 10 lakhs as a amount of Dower at the time of the marriage. So here the non-payment of Dower, Anjum started living separately. So this is the problem which has been given in the examination. So here we have to see how this problem has to be considered. Here these are the facts of the case. Here we need not have to write the classification of Dower. Simply I have mentioned this one for your information. So up to this one we have to write decision and reason for the decision making. So up to this one we have to write. Thereafter we need not have to write. Only these steps we have to follow. So up to this aspect we have to write. So thereafter we are not required to follow. So here there is a specification of amount is there with regard to the payment of Dower. So now I think you understood the problem. Here we have to see you have to frame the issues. That means here framing the issues is also very important. That means there will be the two parties will be there with regard to any dispute. There will be plaintiff and defendant will be there. They will be called as disputants. So there will be two parties will be there. ಅಂದ್ರೆ ಯಾವುದೇ ಒಂದು ಸಮಸ್ಯೆಯಲ್ಲಿ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಇಬ್ಬರು ಕಕ್ಷಿಗಾರರು ಇರ್ತಾರೆ, ಮತ್ತೆ ಅವರ ನಡುವೆ ಒಂದು ವಿವಾದ ಇರುತ್ತೆ. ಅಂತ ಸಮಯದಲ್ಲಿ ಅವರ ನಡುವೆ ಯಾವ ವಿವಾದವಿರುತ್ತೆ ಅದರನ್ನ ಒಂದು ವಿವಾದಾಂಶವನ್ನ ನಾವು ರೂಪಿಸಬೇಕಾಗುತ್ತದೆ. That means we have to frame the issues. So in order to solve their differences. Here what is the issue? Here we can frame one issue or more than one issue. Here whether Anjum is justified in her act of living separately. That is the issue. That means for non-payment of the Dower amount, what Anjum has done, she started living separately. Anjum started living separately. So that is the aspect we can see with regard to this aspect. And second issue is that whether Anjum can enforce for payment of Dower. So she has not been paid Dower, whether she can enforce for the payment of the Dower. ಅಂದ್ರೆ ಇದರಲ್ಲಿ ಏನಪ್ಪ ಅಂದ್ರೆ ಅಂಜುಮು ಒಂದು ಪ್ರತ್ಯೇಕವಾಗಿ ಜೀವಿಸ್ತಾ ಇದ್ದಾಳಲ್ಲ, ಅದು ವಿದ್ಯುಕ್ತವೇ, ಅದು ಸರಿಯಾದ ಕ್ರಮವೇ? ಅಂದ್ರೆ ಆಕೆಗೆ ಡೋವರ್ ಸಿಕ್ಕಿಲ್ಲ, ಆದ್ರಿಂದ ಆಕೆ ಪ್ರತ್ಯೇಕವಾಗಿ ಜೀವನ ಒಂದು ಆರಂಭ ಮಾಡಿದ್ದಾಳೆ. ಅಂದ್ರೆ ಆಕೆ ಗಂಡನ ಜೊತೆಯ ಸಹಯೋಗದಲ್ಲಿ ಇಲ್ಲ. ಇದು ಒಂದು ವಿವಾದಾಂಶ. ಅಂದ್ರೆ ಇದರಿಂದ ಬಾಧಿತನಾದ ವ್ಯಕ್ತಿ ಯಾರು? ಗಂಡ. ಅಂದ್ರೆ ಆಕೆ ಆತನ ಸಹಯೋಗವನ್ನ ಬಿಟ್ಟು ಪ್ರತ್ಯೇಕವಾಗಿ ಜೀವನ ಮಾಡ್ತಾ ಇದ್ದಾಳೆ, ಯಾಕಂದ್ರೆ ಆಕೆಗೆ ಡೋವರ್ ಕೊಟ್ಟಿರುವುದಿಲ್ಲ. ಇದು ಒಂದು ವಿವಾದಾಂಶ. ಅಂದ್ರೆ ಆಕೆಗೆ ಏನು ಒಂದು ಡೋವರ್ ಕೊಡದೇ ಇದ್ರೆ ಆಕೆ ಪ್ರತ್ಯೇಕವಾಗಿ ಜೀವಿಸಬಹುದೇ ಅನ್ನೋದು ಒಂದು ಪ್ರಶ್ನೆ. ಎರಡನೇದು, ವೆದರ್ ಅಂಜುಮ್ ಕ್ಯಾನ್ ಎನ್ಫೋರ್ಸ್ ಫಾರ್ ಪೇಮೆಂಟ್ ಆಫ್ ಡೋವರ್. ಅಂದ್ರೆ ಆಕೆ ತನಗೆ ಸಂದಾಯವಾಗದ ಒಂದು ಕನ್ಯಾ ಶುಲ್ಕಕ್ಕಾಗಿ ಆಕೆ ಒಂದು ದಾವೆಯನ್ನ ಹೂಡಬಹುದೇ ಅಥವಾ ಕ್ರಮವನ್ನ ತೆಗೆದುಕೊಳ್ಳಬಹುದೇ? ಈ ರೀತಿಯಾಗಿ ಎರಡು ವಿವಾದಾಂಶಗಳನ್ನ ನಾವು ಬರೆಯಬಹುದು. ಸೊ here there may be one issue or more than one issue. It may be three also. That depend upon the case. Here the provision of law is applicable with regard to the specified Dower. That means here we can see the provision of law will be applicable is the specified Dower. That is as you know, there is a prompt Dower, deferred Dower is there. Now we can see the aspect of prompt Dower. So there is the prompt Dower will be applicable with regard to this provision of law. And there are number of case laws will be there with regard to this non-payment of the Dower amount. There are number of case laws we can see. Here we can highlight Abdul Qadir versus Salima and Nasra Begum versus Rizwan Ali. So likewise there are a number of cases we can see with regard to the non-payment of Dower, and the woman, that is a wife, she refused to live with the husband. Likewise Marina Jatai versus Nuruddin Jatai. So there also the aspect of this the non-payment of Dower only, it has the cases has been filed. Here we have seen that what is the issue between the husband and wife, and what is the legal importance of the Dower is that under the Mohammedan law, it is a sum of money or other property promised by the husband to be paid or delivered to the wife in consideration of the marriage. That means you know what is the stand under the Mohammedan law. We have to see the provision of law. That means under Mohammedan law, if we can see that it is a sum of money or the property which should be promised by the husband. That means here also Salim has promised to pay certain money, and here what happened, in consideration of marriage, and even where no Dower is expressly fixed or mentioned in the marriage ceremony, the law confers the right of Dower upon the wife as a necessary effect of marriage, even though there is no mentioning with regard to the the amount to be paid as a dower. At that time also, the woman, the wife has got the right to claim the dower as a necessary effect of marriage. So at that time, there is a one more method can be adopted. That means how much the dower can be paid. So how much dower can be paid, that will be seen under proper dower. So that will be considered under the proper dower. So when there is no specification with regard to dower, that will be seen under the proper dower. ಅಂದ್ರೆ ಇವಾಗ ಏನಂದ್ರೆ ಈ ಕನ್ಯಾಶುಲ್ಕದಲ್ಲಿ ಹಲವಾರು ವಿಧಗಳಿದೆ. ಇದರಲ್ಲಿ ನಾವು ಒಂದು ನಿರ್ದಿಷ್ಟಪಡಿಸಲಾದ ಕನ್ಯಾಶುಲ್ಕವನ್ನು ನೋಡ್ತೀವಿ. ಇದರಲ್ಲಿ ಸಮಸ್ಯೆಯಲ್ಲಿ ನಿರ್ದಿಷ್ಟಪಡಿಸಲಾದ ಕನ್ಯಾಶುಲ್ಕ ಇದೆ. ಅದು ಒಂದು ವೇಳೆ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಅದರಲ್ಲಿ ಸರಿಯಾದ ಕನ್ಯಾಶುಲ್ಕದ ಒಂದು ಅಡಿಯಲ್ಲಿ ಒಬ್ಬ ಮಹಿಳೆಯ ಹಕ್ಕನ್ನ ಗುರುತಿಸಲಾಗುತ್ತದೆ. ಸೊ ದೀಸ್ ಥಿಂಗ್ಸ್ ವಿ ಹ್ಯಾವ್ ಸೀನ್ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ದಿ aspect of dower. So here, what is the issue between what is the issue with regard to the Salim and Anjum is that only that is with regard to the non-payment of the dower. So it is appropriate to highlight the case of that is Abdul Qadir versus Salima. Here what happened? Abdul Qadir and Salima, they were happily married to 3 months, and later on Salima went to her father's house and started staying over there. Upon the request of her husband to return back to the Newpital home, her father has declined to let her go. That means here what happens? Here, in case of what you call minor girl, the custodians or father, they have got the right. They can claim for the payment of the dower. So on behalf of the girl, they can ask for the payment of the dower. Thereby, Abdul Qadir had filed a suit for restitution of conjugal rights against her father-in-law and wife. The defendants have come up with the 3 contentions. So here, what happened? The case has been filed against the father-in-law. So here, the petitioner is the Abdul Qadir. He has filed the case against the Salima's father, that is father-in-law, for with regard to the restitution of conjugal rights. ಅಂದ್ರೆ ಇದರಲ್ಲಿ ಏನು ಒಂದು ಈ ಅಬ್ದುಲ್ ಖಾದಿರ್ ಮತ್ತೆ ಸಲೀಮಾ ಪ್ರಕರಣದಲ್ಲಿ ಏನಂದ್ರೆ ಇವರಿಬ್ರು ಮದುವೆ ಆಗ್ತಾರೆ, ಅದರಲ್ಲಿ ಒಂದು ಸಹಯೋಗ ಆಗುತ್ತೆ, ಮತ್ತೆ ಮದುವೆ ಒಂದು ಏನೇನು ಒಂದು ಆಚರಣೆಗಳು ಕಾರ್ಯಾಚರಣೆಗಳು ಇರುತ್ತೆ, ಅದೆಲ್ಲ ಒಂದು ಸುಸೂತ್ರವಾಗಿ ನಡೆಯುತ್ತೆ. ಅವರು ಸಂತೋಷವಾಗಿ 3 ತಿಂಗಳು ಇರ್ತಾರೆ. ನಂತರ ಏನ್ ಮಾಡ್ತಾಳೆ, ಆ ಹುಡುಗಿ ತಂದೆ ಮನೆಗೆ ಹೋಗ್ತಾಳೆ, ಮತ್ತೆ ತಂದೆ ಮನೇಲಿ ವಾಸ ಮಾಡ್ತಾಳೆ. ಮತ್ತೆ ಗಂಡ ಆಕೆಯನ್ನ ತನ್ನ ಪತ್ನಿಯನ್ನ ಕಳ್ಸು ಅಂತ ಹೇಳಿದ್ರೆ ಆತ ಕಳ್ಸೋದಿಲ್ಲ. ಯಾಕಂದ್ರೆ ಅಲ್ಲಿ ಡೋವರ್ ಅನ್ನ ಕೊಟ್ಟಿರೋದಿಲ್ಲ, ಅಂದ್ರೆ ಕನ್ಯಾಶುಲ್ಕವನ್ನ ಪಾವತಿ ಮಾಡಿರೋದಿಲ್ಲ. ಅಬ್ದುಲ್ ಖಾದಿರ್ ಏನ್ ಮಾಡ್ತಾನೆ, ಒಂದು ವಿವಾಹ ದಾಂಪತ್ಯ ಪುನರ್ ಪ್ರಾಪ್ತಿಗೋಸ್ಕರ ಒಂದು ದಾವೆಯನ್ನ ಹೂಡ್ತಾನೆ ನ್ಯಾಯಾಲಯದಲ್ಲಿ. ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸುಮಾರು ಅಂಶಗಳು ಒಂದು ಇದಕ್ಕೆ ಒಂದು ಗಣನೆಗೆ ಬರುತ್ತದೆ. ಸೊ ದೇರ್ ಆರ್ ಸೋ ಮೆನಿ aspects as lifted by the defendant. That means, firstly, there were already a pronouncement of divorce and non-payment of dower and manifestation of cruelty. So all these aspects has been highlighted in the case, but the court has considered only the non-payment of dower. So here, what you have to see, there is a consummation of our marriage is there between Abdul Qadir versus Salima. So the court has considered with regard to the aspect of non-payment of the dower, and Abdul Qadir has deposited the dower amount in the court of law. So the court has asked Salima to go with the husband. So this is the case law of the Abdul Qadir versus Salima. So what we have to see, when there is a consummation of marriage is there, then the wife cannot deny the restitution of conjugal rights what the husband has got in his favor. Suppose the marriage has not been consummated. Suppose the marriage has not been consummated. Then the wife can deny for the restitution of conjugal rights. ಅಂದ್ರೆ ಏನಾಗುತ್ತಪ್ಪ ಅಂತ ಹೇಳಿದ್ರೆ, ಒಂದು ಸಮಯದಲ್ಲಿ ಪತ್ನಿ ಮತ್ತೆ ಗಂಡ ಮತ್ತು ಪತ್ನಿ ಒಂದು ಗಂಡ ಮತ್ತು ಆತನ ಪತ್ನಿಯು ಒಂದು ಮದುವೆಗೆ ಇರುವಂತ ಒಂದು ಯಾವ ಯಾವ ಒಂದು ದಾಂಪತ್ಯದ ಒಂದು ದಾಂಪತ್ಯದ ವಿಷಯಗಳನ್ನ ಅವರು ಒಂದಾಗಿರ್ತಾರೆ. ಒಂದಾಗಿರೋ ನಂತರ ಆಕೆ ಪತ್ನಿ ಒಂದು ವೇಳೆ ಆತ ಗಂಡ ಒಂದು ಕನ್ಯಾಶುಲ್ಕವನ್ನ ಪಾವತಿ ಮಾಡಿದ ನಂತರವೂ ಆಕೆ ಒಂದು ದಾಂಪತ್ಯದ ಹಕ್ಕುಗಳನ್ನ ಆಕೆ ವಂಚಿತನನ್ನಾಗಿ ಮಾಡುವಂತಿಲ್ಲ. ಆಕೆ ತಾನು ಮತ್ತೆ ತನ್ನ ಗಂಡನ ಜೊತೆಯಲ್ಲಿ ತಾನು ಬಾಳೋದಿಲ್ಲ ಅಂತ ಹೇಳಲು ಬರುವುದಿಲ್ಲ. ಯಾಕಂದ್ರೆ there is a contractual marriage is there. She cannot deny the restitution of conjugal rights. So that aspect we have to see with regard to the Abdul Qadir versus Salima. So let us see what are all the facts of the Nazra Begum versus Rizwan Ali. Here, Allahabad High Court held that the right to dower comes into existence before the cohabitation, and prompt dower may be demanded even before the cohabitation. The wife can refuse to live with the husband and admit him to sexual intercourse so long as prompt dower is not paid to her. The court held that the suit for conjugal rights by the husband for the non-payment of the prompt dower before consummation is complete defense and the suit must fail. So here what happened? The Allahabad High Court has said that this right to dower comes into existence before cohabitation. That means before cohabitation, that means here no doubt the prompt dower can be asked at any point of time. But here in the Nazra Begum, the court, Allahabad High Court has held that the aspect of the payment for the payment of dower, which can be asked at any point of time. But here the point for consideration is that whether a woman can refuse the husband for the cohabitation, because there is no consummation of marriage. That means it will become a complete defense. So she will be justified in denying the conjugal rights to the husband, because there is no consummation of marriage. So that is the difference between the Abdul Qadir versus Salima and Nazra Begum versus Rizwan Ali. ಅಂದ್ರೆ ನಜ್ರಾ ಬೇಗಂ ವಿರುದ್ಧ ರಿಜ್ವಾನ್ ಅಲಿ ಏನಪ್ಪ ಈ ಅಲಹಾಬಾದ್ ಉಚ್ಚತಮ ನ್ಯಾಯಾಲಯ ಏನ್ ಹೇಳುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರೆ, ಒಂದು ವೇಳೆ ಈ ತತ್ಕ್ಷಣಿಕ ಒಂದು ಕನ್ಯಾಶುಲ್ಕವನ್ನ ಯಾವ ಸಮಯದಲ್ಲಿ ಪಾವತಿ ಮಾಡಬಹುದು ಅಂದ್ರೆ ಯಾವ ಸಮಯದಲ್ಲಾದ್ರೂ ಅದನ್ನ ಪಾವತಿ ಮಾಡಬಹುದು. ಆದ್ರೆ ಒಂದು ವೇಳೆ ಗಂಡ ಮತ್ತೆ ಹೆಂಡತಿಯ ಜೊತೆಯಲ್ಲಿ ಒಂದು ವೈವಾಹಿಕ ಸಂಯೋಗ ಆಗದೇ ಇದ್ದ ಸಮಯದಲ್ಲಿ ಆಕೆ ವಿವಾಹ ಪುನರ್ ದಾಂಪತ್ಯದ ಹಕ್ಕುಗಳ ಸ್ಥಾಪನೆಯನ್ನ ನಿರಾಕರಣೆ ಮಾಡಬಹುದು. ಆಕೆ ತನ್ನ ಗಂಡನ ಜೊತೆಯಲ್ಲಿ ಹೋಗದೇ ಇರಲು ನಿರಾಕರಣೆ ಮಾಡಬಹುದು. ಯಾಕಂದ್ರೆ ಅಲ್ಲಿ ತತ್ಕ್ಷಣಿಕ ಒಂದು ಕನ್ಯಾಶುಲ್ಕವನ್ನು ಪಾವತಿ ಮಾಡಿಲ್ಲ, ಮತ್ತೆ ಮುಖ್ಯವಾಗಿ ಅಲ್ಲಿ ವಿವಾಹದ ಸಹಯೋಗ ಆಗಿಲ್ಲ. ಸೊ she will be justified in denying the cohabitation with the husband. So this is the thing we can see under the Nazra Begum versus Rizwan Ali. I think you are following what is the crux of the case. Here we have to analyze this aspect. We have to analyze the fact. We have to see the issue. We have to discuss the provision of law. Here these things we have to analyze in this section, in the analysis section. ಅಂದ್ರೆ ನಾವೇನಂದ್ರೆ ಇಲ್ಲಿ ಸಂಗತಿ, ವಿವಾದಾಂಶ ಮತ್ತೆ ಕಾನೂನಿನ ನಿಯಮಗಳನ್ನ ಈ ವಿಶ್ಲೇಷಣೆ ಇದರಲ್ಲಿ ನಾವು ಅದನ್ನ ಚರ್ಚೆ ಮಾಡಬೇಕು. ಇದರಲ್ಲೇನಂದ್ರೆ ಅದನ್ನೇ ಬರ್ದಿಡೋದು, ಯಾವ್ದು ಫ್ಯಾಕ್ಟ್ಸ್ ಏನಿದೆ, ಪ್ರಾವಿಷನ್ ಆಫ್ ಲಾ ಏನಿದೆ, ಮತ್ತೆ ಏನಿದೆ ಫ್ಯಾಕ್ಟ್ಸ್, ಇಶ್ಯೂ ಮತ್ತೆ ಪ್ರಾವಿಷನ್ ಆಫ್ ಲಾ, ಈ ಮೂರನ್ನ ಬರ್ದಿಡೋದು. ದಟ್ ಮೀನ್ಸ್ ವಿ ಹ್ಯಾವ್ ಟು ರೈಟ್ ಆಲ್ ದೋಸ್ ಥಿಂಗ್ಸ್, then we have to analyze this one. Here the facts of the case, the same thing, we have to write that one. And what is the issue? The same thing what we have discussed earlier. And we have to write we have to analyze. So this one is very much important. As per Muslim law, dower is consideration of the marriage, and Muslim married woman, she is entitled for it. That means, that is even though it is given for as token of respect. So it is believed that it's a consideration of the marriage. So in the instant case, so we have to write this one, instant case. So there is a specified dower is present, whereas the Muslim wife is just in living separately for non-payment. So if whereas the Muslim is just in living separately for non-payment, if the marriage has been consummated, till this we have to read. So here what is the important thing is that, so in the instant case, there is a specified dower is present. So full stop, up to that one is full stop. So here what you have to see, whereas the Muslim wife is just in living separately for non-payment. I have not said with regard to this problem. I am analyzing the concept here, whereas the Muslim wife is just in living separately for non-payment. Here I am highlighting the case law of Nasra Begum versus Rizwan Ali. So if the marriage has not been consummated, then she is very much right in denying the restitution of conjugal rights. Here marriage has been consummated. If here in this case the marriage has been consummated, as we can see under Abdul Qadir versus Salima. So here also the marriage has been consummated. That means they have lived happily for certain period. So that is Salim promised Anjum that he would pay 10 lakhs as dower in the event of marriage. Here, despite of her repeated request, that means where she can request, she lives with the husband, and he neglected to keep up his promise. Being aggrieved, she started living separately. Thereby, she left the cohabitation of the husband. So we can see she lived with the husband. Cohabitation is the marriage has been consummated. So she cannot deny the restitution of conjugal rights if the suit has been filed. So here marriage has been consummated. So plaintiff can ask for the payment of dower. That means what is the remedy left for the bride is that, what is the remedy left for the Anjum is that she can ask for the payment of dower as a debt from the defendant. That means she has got all the rights to enforce for the dower as a debt. So in the light of the above said case, if the suit for restitution of conjugal rights, the rights petition has been filed, she cannot deny the restitution of conjugal rights. So, but she cannot deny, but she can insist for the payment of dower. That means the court will consider the request definitely, because dower is the important aspect with regard to the Muslim marriage. Here, this is the analysis section. What we have analyzed all these things, the facts of the cases we have analyzed the issue, and we have analyzed the rule of law also. Here, all these things we have analyzed. So, we have to, after analysis, we have to write the decision. That means we have to write all these things in the analysis section. That is the facts and the issues and the case laws. That is what is there in the case law. We have to judge the case law also. So there we have to write the decision and reason for decision making. Anjum is not justified in her act of separate living as her marriage has been consummated. But when case for restitution of conjugal rights case has been filed, she can demand for payment of meher, or she can file separately a case, analyze case to recover the debt. So she can file a case, the case which can be filed to claim the debt. So in this way, she can file the case for to recover the debt. So that is the remedy available to the Anjum. So she can file the case to recover the debt. To recover the debt, that is meher, she can file the separate case against the husband. If the restitution of conjugal rights, the suit has been filed her husband, she cannot deny the rights of her husband. But in that suit, she can ask for the payment of the meher amount. ಅಂದ್ರೆ ಏನಪ್ಪಾ ಅಂದ್ರೆ ಈ ತೀರ್ಮಾನದಲ್ಲಿ ನಾವು ಏನ್ ಬರಿಬೇಕಂದ್ರೆ, ಈ ಅಂಜುಮು ಗಂಡನ ಸಹಯೋಗದಲ್ಲಿ ಇದ್ದಿದ್ದರಿಂದಾಗಿ ಆಕೆ ಏನು ಅಂದ್ರೆ ಆಕೆ 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 ತನಗೆ ಬರಬೇಕಾಗಿರುವಂತ ಒಂದು ಮೇಹರ್ ಅಮೌಂಟ್ ಅನ್ನ ಪಡೆಯೋದಕ್ಕಾಗಿ ಆಕೆ ಒಂದು ದಾವೆಯನ್ನು ಹೂಡಬಹುದು. ಮತ್ತೆ ಒಂದು ವೇಳೆ ವೈವಾಹಿಕ ದಾಂಪತ್ಯ ಪುನರ್ಪ್ರಾಪ್ತಿಗಾಗಿ ಯಾರು ದಾವೆ ಹೂಡಿದ್ದೆ ಆದರೆ ಆಕೆ ಅದನ್ನ ನಿರಾಕರಣೆ ಮಾಡಲು ಬರುವುದಿಲ್ಲ. ಸೊ ವಿ ಹ್ಯಾವ್ ಸೀನ್ ದಿಸ್ ಆಸ್ಪೆಕ್ಟ್ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ದಿ ಕಾನ್ಸೆಪ್ಟ್ ಆಫ್ ಡೋವರ್. So this is very much important with regard to the how to solve the problem with regard to the Dower. So in our the continuous classes we can see the solvation of the problems with regard to the Mohammedan law.